Hello, this is Attorney Shaprali from the Shaprali Law Group, and we're going to talk a little bit about priority dates. Priority dates is very important, especially for people, for family petitions, but more importantly, oftentimes for employment base, for people who are from India, China, sometimes from the Philippines, depending on the visa built-in. And one of the big important thing for people to do, and people who are beneficiaries of green card, is to actually maintain this priority date, because earlier the priority date, better are your chances of getting a green card earlier, of course. So basically, locking the priority date on an I-140 is somehow to stand in the line, and you can use that and carry it usually forward on any kind of petitions when it comes to employment base. And sometimes you can even put family dates, priority dates, but in this case we're going to talk specifically about employment case. What has happened in certain situation is, as far as we know, and for a long time, we have always been able to use the priority date of cases, whether it was from an EB3 moving to an EB2, as long as the I-140 was approved, and also the I-140 was not obtained in fraud or any kind of misrepresentation. But recently, in in November 2014, BIA, the Board of Immigration Appeals, came with a decision which kind of goes against all our knowledge as lawyers. And now, in the matter of Ray Grace Estrelado, the case was issued in 2014 November, and that person had an I-140 from 2006, and the BIA refused to port that I-140 priority date, citing that basically the employer revoked that I-140. And the truth is that this is not really what the law has always been saying and what we have been following under the foreign guidance, foreign affairs manual. But unfortunately, the problem that we're facing now is because of this one case, which, by the way, I should mention, is not a precedential case. That means BIA has not mentioned it can be used on other cases. And two, BIA technically don't have jurisdictions on I-140s. However, BIA has jurisdiction on the I-45, which is an adjustment of status. As such, them picking that priority date becomes important. But so far, that law is not precedential. That means cannot be used as precedence. And two, that law can be fought. They have not expanded it really to other cases. So if you have a priority date which is there, even the I-140 have been revoked, my recommendation is to try to still use it, and later on find out if the USCIS refuse it. And again, since that case is not binding, it should not have an effect on what we have done in the past. But unfortunately, because of that one case now, there's a lot of confusion out there. It's creating a lot of problem. I hope this case will go to higher level and will be reversed, because that's just that one simple case which should not be there is causing a lot of havoc, and people are confused, worried about their priority dates. So bottom line, the advice is to go ahead and continue using your previous priority date, even if the I-140 has been cancelled, unless it's stated otherwise. So ladies and gentlemen, this is Attorney Shaprali signing off for another part of this How to Guide series. Please share it with your friends, and anything I told you today is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. The number to our office is 510-742-5887, and the website is piralilaw.com. Please check in and subscribe to our channel and check our website. Thank you. Until the next video, I say goodbye.